Hi, Jane. If you don't mind, I would be interested to follow up with some of the things that we discussed in our guest blog a few weeks ago.
Oh, thank you, Richard. No, that would be, I'd be delighted to participate in that.
And I don't get to ask the questions often, so I'm looking forward to this.
I just hope you don't ask any questions I can't answer.
I'll try not to. Well, Jane, where is Australia at now in terms of, let's look at anti-bribery enforcement, whether it's investigatory and prosecutorial resources, as well as corporate compliance. There's a lot going on in the press right now in Australia, so what's the current state of affairs?
It's an interesting question, Richard, and thank you. It's from a political level, I have to say there still seems to be a lack of political will, if I can say that, about really addressing some of the shortfalls within the legislation and really addressing the concerns that have been raised by a lot of the community, albeit the press or the business sector. But as you clearly identify, there's a lot more awareness now of bribery and corruption and the impact bribery and corruption has within Australia and externally. And also a lot of the states and territories now have their own independent anti-corruption authorities or regulators who are investigating allegations of corruption within those particular jurisdictions. So for example, in New South Wales, we've had a series of very revelatory public inquiries into allegations of corruption by politicians and some people in the private sector who've been participating in that conduct within New South Wales. Having said that, what we have found is that there's particularly members of the press who've become a lot more fascinated and a lot more engaged with anti-bribery and anti-corruption, and they're starting to really reveal a lot of concerns that have been raised overseas and within Australia. So, for example, we've had BHP Billiton has been mentioned in the press, investigated by US authorities, but it's also currently being investigated by the Australian Federal Police. Leighton Holdings is another construction company that operates all around the world, and it too is being investigated by the Australian Federal Police. Having said that, a lot of the AFP, as we refer to them, don't tend to be very forthcoming in revealing the names of companies or individuals that they're investigating. So, although these questions are asked on a regular basis, they tend to only inform people about those companies about which there is public knowledge in the first place.
Mm-hmm.
What's been interesting is that there's now been increased focus on enforcing corruption, or at least charging corruption within Australia. So we've had recent examples with the Commonwealth Bank of Australia where a couple of senior executive managers were charged with receiving bribes in order to provide contracts in the IT section. And more recently, we've had Coca-Cola Amatil and a freight forwarding company called Oryx, who've both been charged, or individuals within those companies have been charged with paying bribes. So that there's increasing awareness from the company side. There's a Senate inquiry that's going to actually seek more information from companies such as BHP Billiton and Leighton Holdings. So again, you're getting more awareness from a target of particular companies that have been the subject of public disclosure, but you're also getting individuals who are targeted as well. But I think, Richard, it's a very moving feast within the Australian landscape, and I think we'll see a lot more changes over the next 2 to 5 years, to be honest. I think it will take that long to really play out comprehensively.
So in the US, there are some pieces that have talked about compliance fatigue on the part of corporations. It doesn't sound like Australia has yet, from the corporate side, reached compliance fatigue, as I would imagine that corporations now are first trying to figure out how to deal with this effectively, to do business, but to do business that's also in compliance with international and local anti-bribery laws.
Yeah, that's a very good point, Richard. And certainly a lot of the very big companies that are subject to the US laws and UK laws do actually have very comprehensive anti-bribery compliance programs in place, and they tend to take those very seriously as well. Some of the concerns can be with some of the major Australian companies, and certainly a lot of the small to medium enterprises who feel it's still part of a ticking the box exercise.
Right.
I've had the head of security and the general counsel of one very well-known company say to me that from their perspective, this was a few years ago, that they felt that the AFP didn't have the resources or the interest in pursuing that kind of crime because they're really focusing now on anti-terrorism, and that tends to be the focus.
Mm-hmm.
Going back to your previous question, the AFP probably could use more resources, certainly have more resources than they did in the past, but they certainly could use a lot more resources in the future to really try and address these kinds of investigations, because they are very, very time intensive and resource intensive, and it's really drawing on a set of skills that the AFP have only really started to acquire. But going back to this particular question, there is some companies have compliance fatigue, but those are the ones that have been subject to US and UK laws in any event. The smaller companies still have got a long way to go.
Is there much chatter in Parliament about having to rewrite some of the overseas anti-bribery acts, or is there a feeling like the legislation is strong enough, it just needs to be enforced?
At this stage, it's pretty much the latter. I certainly know that there has been some concerns by authorities and by Transparency International Australia that the law itself would be very difficult to enforce. And I'm certainly aware that in relation to one prosecution or a number of prosecutions that are underway at the moment in the Supreme Court of Victoria, that the charges are actually aiding and abetting the contravention law as opposed to the foreign bribery laws themselves. So there's still no precedent to really have a strong comprehensive understanding as to how difficult it will be to enforce that law in Australia. And so I think the politicians have been very reluctant to do anything about it until they've actually got substantial evidence in front of them that the law itself is difficult to enforce.
So you probably don't hear much of the debate in Australia that you hear in the US about, is there too much corporate enforcement and not enough emphasis on charging individuals?
Not at this stage. Certainly, as I mentioned before, the Senate inquiry is really looking at BHP Billiton and Leighton Holdings and various other companies that are being mentioned in the press. Having said that, when prosecutions do occur, they also do target the individuals. So again, how they do that is still playing out in a very difficult kind of way. So, for example, just recently, or about 18 months ago, one of the directors, or this chief financial officer of the Australian Wheat Board that was caught up in the oil for food program and against the UN sanctions, or contrary to UN sanctions, mid-noughties and mid-2000s, reached an agreement with the Australian Securities and Investment Commission. And that was a civil charge in the end under the Corporations Act. And that took about 7 years to negotiate. So I think, again, we need to really watch this space to see exactly how long it's going to take for some of these prosecutions to get through to conclusion.
Well, then I hope you won't get too immersed in the Bribery Act when you go over to the UK, and you'll continue to follow developments in Australia as I will go to you for future updates.
Thank you very much, very much, Richard. I really enjoyed speaking with you this morning.
Likewise. Thank you, Jane.